Hello? I can't see anyone here, so I am live now. If you can see me, just say hi in the comment, in the chat section. Just type hi. If you are seeing me, can you type hi in the chat section so that I can know the people who are with me? I'm still expecting the guest. Oh, okay. So there are so many people already. Yeah. Thank you for showing up for me. Thank you for joining me live this Saturday. I'm still expecting the guest. He'll be here to answer all of your questions, so just get them ready. For those who have applied for study permits and their visas were refused, for those who have some inadmissibility issues, like maybe you have a medical issue, you're not sure if you're going to get a Canadian visa, if you must have committed a crime sometime in the past and it's going to affect your application, whatever, this is the place to ask those questions because you're going to be talking to an immigration lawyer. So thank you so much. Can you tell me where you're from? If you're from Nigeria, South Africa, Uganda, Cameroon, Ghana, wherever you're from, just let me know in the chat section so that I can say hi to your country and where you're from. Oh, I can see someone from Jamaica. Okay, Nigeria, Dubai is representing. Okay, from just Nigeria representing, UK French citizen representing. Thank you so much for joining me. Ghana is representing. Philippines is representing. Thank you so much for joining me. Italy is represented. Czech Republic is also represented. Thank you so much for joining me. Kenya, I can see you. India, Gaurav from India, thank you for joining me today. Chooks from Congo, thank you for joining me. Yeah, so thank you so much for joining me on this live. Cayman Islands and Jamaica, Chanel, thank you for joining me on this broadcast. Thank you so much. Imo from Nigeria, Chiedo, thank you for joining me. Dubai, Huzaifa from Dubai, thank you so much for joining me. I'm really appreciative of this meeting. I really thank you so much. Blessing from Italy, thank you so much. Nkosi from South Africa, thank you so much. How is South Africa? I was in Cape Town sometime in 2013 and I've not been able to go back to South Africa. Maybe one of these days I'll try to explore these places. Okay, Rwanda, I can see from Rwanda, Namibia. Annie from Rwanda, thank you for joining me. Namibia, so thank you so much. Our guest is here, Mr. Francis. Thank you so much for joining me on this live. I am so appreciative. Please, can you hear me, Mr. Francis?
Yes, okay. I'm hearing you loud and clear, Wula. Thanks for having me. It's a pleasure. Okay. Pleasure to be on with you.
I've been saying hello to all the people from different parts of the world. We have people from Namibia, Rwanda, Italy, Cayman Islands, Angola, Cameroon, Ghana, from Israel. I can see somebody from Israel right now. So I have so many people from all over the world joining me on this live. And I am
this is really awesome.
Yeah, I'm really appreciative for you to come as a Canadian immigration lawyer. A lot of people have had so many issues, and they are here to ask their questions. So even people from UK, France, everybody, they just want to ask their questions. So we will be spending 30 minutes to talk about the inadmissibility issues, like things that will make people not get their visas to Canada, and how they can resolve those issues. I know majority, one of the major issue is misrepresentation. There's also medical inadmissibility. There's also security, and maybe if a family member also must have had a misrepresentation issue. So I want you to talk about these issues, and then we'll talk about the visa refusals, and then we'll talk about the judicial review process, and then we'll take the questions from these people. Okay. So it's Mr. Francis, and he is from Goose Law. He's a Canadian immigration lawyer, and he's the best person to ask all your questions to. So I am not an immigration lawyer, and I have him here to answer those questions. So, okay, Mr. Francis, you can go ahead.
Thank you. So first off, thanks a lot, Wola, for taking the time to invite us onto your channel to chat with your subscribers, and just to help people with all the many questions that they have about getting to Canada. So there are a lot of questions. So I guess you want us to well, let me start by introducing myself. So I practice exclusively Canadian immigration law. I'm based in Toronto, but we practice virtually. So our clients are from all over the world. We have a lot of Nigerian clients. I didn't hear you mention Nigeria, Wolo. Are there no Nigerians in the house?
There are lots of Nigerians on this channel. Like, you have people from different parts of Nigeria, Jos,
yes,
Imo, Port Harcourt, Lagos State, Abuja.
Okay.
No, from every part of Nigeria. So if I just mention Nigeria, there are lots of them. But I still have lots of people from all over the world, like Cayman Islands.
Yes.
I'm surprised someone from Cayman Islands is also joining.
Yes.
Czech Republic is also here. So lots and lots of people from all over the world. Yeah.
Excellent. So yes. So we support clients from all over the world, and we do what we do virtually. So we have clients from all across Africa, Nigeria, a lot of Nigerians, a lot of Ghanaians, Kenyans. We have people from the Caribbean, Jamaica, the Cayman, Bahamas, and we have people from Europe, from the UK. We've had a few clients from Sweden and a few other, and France, plus clients from the UK. So we service clients globally, and we're able to do that by offering our services virtually, through Zoom and all of these stuff. And in a lot of ways, this whole coronavirus thing has been an eye-opener, because it has made people aware that they are actually able to get immigration support without actually having to be physically present in Canada or any place. So that's a good thing. So yeah, my wife and I moved here from Jamaica many years ago. We moved to a province that's close to where you are. You're in Manitoba, right?
Yes, I am in Manitoba.
Yeah, so we moved to Alberta, which can get pretty cold. You know a thing or two about cold temperatures.
Yeah.
Right? Yeah, so we were in Alberta, which gets just as cold as well. So we moved here as immigrants, and so we understand the experience that goes into coming to Canada as an immigrant. We understand what's required to come. We understand that the process can be intimidating, especially for somebody who has never done anything like that before. But it's a process that if you have all of your facts and if you have good guidance, it's a process that can be overcome. Naturally, there are barriers, there are hurdles that could impact one's ability to come to Canada, and you referred to them as inadmissibility challenges, right? So an inadmissibility really means that you are not likely to be admitted into Canada because of one of many reasons. Canada's immigration rules prevent persons from being admitted into Canada if certain things apply. For instance, if you are somebody who has had a criminal issue, a serious criminal issue in the past, then chances are that that could potentially impact your chances of coming into Canada. It doesn't mean that you'll never be able to come into Canada, but it means that it may limit what you may be able to come to Canada to do, and it may impact ultimately whether or not you may be able to be admitted into Canada. So that's known as criminal inadmissibility. So something like driving under the influence, for instance, we've come across clients from the US, for instance. In the US, the offense of driving under the influence, drunk driving, in many states, it's not treated as seriously as it is in Canada. And because of that, we often see some clients coming from the US who have a DUI, driving under the influence charge, and who find that they are not able to be admitted. They're inadmissible to Canada because of that charge. So a simple charge like that could potentially prevent somebody from coming into Canada. And so, of course, there are always going to be options to overcome that. But that's where the lawyer comes in, and we can talk about those afterwards if that's something you want to touch on. So that's criminal inadmissibility, and I mean it gets a lot more detailed, a lot more technical. But just kind of speaking broadly, criminal admissibility has to do with where you would have been charged or convicted of a serious crime, right? A crime which in Canada would fall into the category of a serious criminality. And there's a long list of those. So that's one reason you'd be inadmissible on criminal grounds. I don't know if you had questions about that specifically, or if you want me to touch on the other types of inadmissibility, which I'm happy to do.
I'll be showing one person's question. He says, I was
Yes.
denied based on misrepresentation. So this is from Nigeria. So maybe you could expatiate on that as well, and how he can overcome that.
Good question. So that's another form of inadmissibility, misrepresentation. And misrepresentation pretty much means that you have either misstated a fact, a material fact, and by material fact we mean a fact that is critical, a fact that is so important that it could otherwise have impacted your application. So you might either have misstated a fact, or you might have omitted a material fact. You might have neglected to include something that's important to the application. Maybe you didn't mention the fact that you were denied an application before. We've seen instances where persons sometimes they forget, or sometimes they think it would harm their application, so they don't mention the fact that they had been denied an application in the past. And something as simple as that could potentially lead to you being found to have misrepresented. Now, if you're found to have misrepresented, then what that means is that the regulations stipulate that you would then be subject to a 5-year ban from Canada, which means that you would not be able to apply to re-enter Canada successfully until 5 years have passed since you committed the misrepresentation. So that's a challenge with misrepresentation. Of course, I mean, there's always the option, if you need to come to Canada before the 5 years have passed, you have the option of applying for something called an ARC, okay, which is an authorization to return to Canada. Now, I mean, it's an option, but it's going to be a challenge, all right? Because what you need is, you'd be needing special authorization from the minister, meaning a special authorization from the immigration authorities to allow you to come to Canada, notwithstanding the fact that you would have been banned for 5 years. So it's going to be very difficult for somebody who's been banned from Canada for misrepresentation to be successful in getting readmittance to Canada. But that said, there is an avenue for persons to apply under an ARC, authorization to return to Canada.
Okay, so I have a question from someone who says, is it possible that those of us, because there was an NSAS movement in Nigeria, and they are saying that because they protested, is it possible that they can be denied the chance of getting a visa on the grounds of working against their country? So is it seen as a serious crime or something that would affect their visa application?
No, that's a good question, because one of the grounds for inadmissibility, I mean, has to do with working against, say, your country, or engaging in some kind of human rights related type of issue. So the critical thing here is that we would need to understand if this particular person has actually been charged with some kind of an offense, charged or convicted, right? And then we would have to see the nature of the charges or the conviction and compare them to what's here in Canada to see if there's what's called an equivalency, right? So I wouldn't be able to say yes or no to that question, but I can explain the process. And the process is that the first thing is we need to understand if this person has been charged. If there's a charge or if there's some kind of a conviction, then that's the first thing. The second thing is that if there is, then we'd need to assess it to see where it fits inside of the Canadian criminal regime, inside of Canadian criminal code, to see if it's on par with what we have here. And then based on that, we'd be able to advise if or how that charge or conviction block or prevent that person from coming to Canada.
Okay, there's another question here. I think it's regards to a temporary resident visa for study permit. She said the friend was denied twice, but she's thinking of using a lawyer to file for study permit. What are her chances of getting a study permit if she files with a lawyer, or if she uses, let's say she wants to hire your services, Goose Law, file for her study permit? Will there be a possibility of her getting the temporary resident visa?
Yes. So there's always the possibility of a visa being approved after it was initially refused. In fact, we've personally seen cases where an application had been refused 3 times before and was approved on the 4th attempt. That said, it's important to bear in mind that ultimately the decision to approve or deny an application rests with the Canadian immigration officer. And so no lawyer or consultant can provide any guarantees as to whether or not an application is going to be approved. However, there are certain things that a lawyer will be able to do that are going to strengthen your application, right? And what a lot of people don't understand is that if your application has been refused, it makes no sense reapplying using the same information. What you need to do is you need to understand the reasons for the initial refusal. In fact, there's a famous Canadian case called Baker. There was this woman who had come to Canada, and she was about to be sent home, and the officer made a decision to refuse her application, and he provided no reasons. He gave her no reason for the refusal. They just said, "You're refused." And so that went all the way to the federal courts, and the federal courts ruled that the immigration authorities have an obligation to provide written reasons for a refusal. However, those reasons aren't given to you when they send you the refusal letter. The refusal letter has just some generic wording in there. You have to apply for something called an ATIP, an Access to Information and Privacy Request, right? And you can only do that from inside Canada. So you'd have your lawyer apply for that. And when you apply for that, there you'll see the actual notes that the officer wrote. And the notes will tell you, okay, this person did not show enough ties, that we weren't able to verify this person's travel history, so we don't know what they were doing over the past 10 years. We don't see a logical connection between the program of study that they're wanting to do in Canada and their previous study back home, and all of these things, right? So once we're able to see what the true reasons are, then we file the new application and we address those issues in the new application. But the last thing you want to do is to just go ahead and refile and continue refiling. Your application will not be approved if you don't address the specific reasons which the officer must provide in their notes, which are going to be with the immigration authorities.
Okay, for those who don't know, the ATIP is also known as the GCMS notes. So that's what he's actually referring to. So the GCMS notes is actually needed for a lawyer or for a consultant to really know the reasons why your application was refused. So, and that brings me to, let's say the visa officer just decided to refuse the application because there was someone who sent me an email, even when it was a consultant that actually put in the application on his behalf, it was still refused. And the reason they gave was that he doesn't have enough funds, whereas he had enough funds. He had paid his tuition fees upfront. He also showed enough funds, about 30,000 Canadian dollars, with a support from his brother of about $80,000. But the visa officer still mentioned that he was still refused his application. So in this case, so knowing fully well that all the documents, all the proof was provided, and he was still refused his study permit visa, what will be the next logical step that you think he should take, considering that
Yeah.
he
So
was refused the first time, and then he was refused the first time because he applied himself. He contacted an immigration consultant, and they put his documents, everything together again, using all the necessary information was provided, and he was refused the second time again. So at this stage,
right.
what do you suggest this person does?
Yeah. Okay. So without seeing the details of that person's, it's always important to kind of see the reasons that the officer gave, the specific reasons, and also to see the response that was formulated in the second application. So when you apply, when we apply on behalf of a client, we not just do the application, we do what's called a legal submissions letter. Okay. And this submissions letter is where we make legal arguments and we rebut each of the reason that the officer would have stated in the refusal of the previous application, right? So
Yeah.
that's going to be important, how effectively this person would have gone about addressing each and every one of the concern that the officer would have raised and refuting and rebutting each. That's important. But let's assume that that was done and that was done effectively. And the officer still ended up refusing the application, then one of the things we might want to do before thinking about appealing is seeking what's known as a reconsideration. Okay, and the reason why we want to put off appealing to the very last is because it's a lengthy process and it's expensive, and we want to save our clients having to go through that. And so if there are other avenues that we can explore that can lead to a positive outcome, then we want to explore those first. And so I'd probably, if we're satisfied that the officer really made an error, whether it be based on law or mixed or law and facts, then we probably want to look at asking for what's called a reconsideration. So this is as soon as you get the negative response, we would reach out to the immigration authorities on behalf of the client and point out to the authorities that we believe that a mistake was made because X, Y, and Z, and we'd state the facts. We'd pretty much make a new argument inside that reconsideration, asking the officer the officers or the manager in charge of the consular office that made the decision to reconsider. And we've seen cases where they've come back and said, okay, it's approved. There was an obvious and clear error. Okay, so that's an option. If for whatever reason we determine that that's not a viable option, then there's always going to be the option to appeal. And when I say appeal, really what a foreign national who's applying for a visa that's been refused, what they can do is really apply for what's called a judicial review, right? I just use the word appeal kind of in the generic sense, but they would have to file for what's called a judicial review. And this is something that happens inside Canada's federal courts. You need a lawyer to do this on your behalf. And before you apply for this, you'd have to first apply for something called leave. You'd have to seek leave from the courts to allow you to challenge this decision in the federal courts. And seeking leave really means you have to go to the courts and say, I think I have a valid case. Please let me know if you agree with me that I have a valid case. And if the court says, yes, you have a valid case, then it means that you've been granted leave and you may now go and challenge the decision in the federal court. And this is known as judicial review.
Okay, so for anybody who has had his situation gotten to this point where you applied for study permit, it was refused, and you're very sure that you provided all the necessary documents, I think the next best step is actually the reconsideration request. But I read somewhere where they said most times reconsideration request does not really come out as successful. The rate of success is not as high as that of a judicial review. So would you advise that instead of them going for reconsideration, they just go straight to judicial review? Or
so ultimately that call is going to be up to the client, right? What we do is we put the options out there and say, okay, you choose. I think you're right in to the extent that reconsiderations, the success rate is not as high as could be desired. But you also have to take that into the context that not everybody who is seeking reconsideration has a strong case, right? So if everybody whose application is refused applies for reconsideration, chances are the significant majority of them will continue to be refused. So we recommend reconsideration in instances where, like the one you referenced earlier, where everything suggests that this person has not only met the requirement, this person has exceeded the requirements. Right? So in those kinds of select cases, you want to seek reconsideration. If it's a case where we think that the officer may be justified or it's not a 100% certain case, then we might recommend refiling, reapplying, rather than doing a reconsideration. But ultimately, there will always be the option of doing a judicial review. But I like to tell clients that a judicial review is it's a major undertaking. You're literally hiring a lawyer to go stand before the Federal Court of Canada to argue that your study permit application should be granted, and that's going to cost you more. It's going to be more time consuming, and so I always like clients to be aware of that beforehand, upfront, and so that they can choose ultimately which option is going to work for them. But I found that the judicial review avenue is really a last resort, and it's not always necessary if your application is really structured properly, and if all the issues, all of the reasons for refusals are addressed adequately.
Is there I wanted to ask what's the average cost of let's say hiring you if one wants to hire you for a judicial review? What's the average cost? But before I go to that point, I wanted to ask, is there a possibility of, let's say, doing the judicial review and then applying for a settlement out of court? So you don't go through the whole process if the leave is granted, right? So you settle out of court and then you know that they just have to look at the application all over again without going through the steps of going to the court if the leave is granted. So maybe you could answer both questions at the same time. The cost of judicial review, and let's say one wants to do a settlement out of court.
Yeah, I'm not familiar with the settlement process. Once you file for leave seeking judicial review, then what it means is that your case is going to be going before the Federal Court of Canada, and the chances of your application being approved really is going to come down to the decision that's made inside the Federal Court of Canada. So, I mean, we try to be very direct, very upfront with our clients, and say that the judicial review process, it's an option, right? And it's an option that others have used successfully in the past. However, it's going to be time consuming. It's going to be costly. You asked about cost. We're talking anything upwards of 6,000 Canadian dollars, and it may vary depending on the amount of time that's involved in that process.
Okay, let me move on to the next question. This person says there was a ban placed on my application due to fraudulent bank statement document, and I was asked to reply, and 2 weeks later I got a mail that my application is still ongoing. So I don't understand this part of the question. When they say fraudulent,
they probably
yeah.
they probably got a fairness letter,
Okay.
which typically is a letter that says we have suspicions that your documents may be fraudulent. Please provide us with evidence to convince us that that's not the case, or something like that. So I'm speculating that that might have been what happened in that particular situation.
Okay. I'm trying to look for questions relating to the topic. Okay, so this one says, when filing the visa application, questions like, have you been denied visa previously in the last so years? Should we answer yes if we have been denied visa, but it wasn't Canada? I think you've treated that before. Maybe you could say it again.
Yeah, absolutely. You want to be truthful, and that question applies to a refusal, and it says so in the application form. It says, have you been denied a visa or some kind of immigration application for Canada or any other country? And so that applies right across the board. And failure to indicate yes potentially will lead to you being found to have misrepresented. And the penalty for misrepresentation is a minimum 5-year bar from Canada. So you absolutely want to say yes for that one.
Okay. So the next question, what if a misrepresentation was not spotted by the VOs in a past application? Can it affect a current application that is completely honest?
Yes, it could, right? A misrepresentation is a misrepresentation. And if it wasn't spotted in the past, it doesn't mean that it's not going to impact you going forward. In fact, even where persons have become permanent residents, if it is discovered after you've become a permanent resident that you gained your permanent residency on the basis of some prior misrepresentation, then what it means is that you are at risk of having your permanent residency revoked, based on the fact that there was a misrepresentation in the past. So a misrepresentation on your immigration documentation remains that, even if it had been missed initially.
Okay. Okay, I hope the person gets this. I hope the person is still here. Then the next question was denied because of proof of funds, but I have a job offer and a provincial nomination, so did not know I have to show proof of funds. How much do I have to show as I have a job offer? I don't know if this is related to the topic. The person was denied because of proof of funds before. I don't understand how the person was able to apply, or which stream the person was applying under. It's quite complex. The question there is not clear. So maybe I would look for another question. Can we talk about medical inadmissibility?
Yes. Good question. So Canada's immigration rules also may potentially prevent persons from coming to Canada if the authorities determine that that person has a medical condition that could create harm to Canadians, or that could lead to what's called creating excessive demand on Canada's healthcare services or Canada's social services. So it's kind of a two-pronged thing. If they've found that you have some kind of an infectious disease, for instance, we're in the middle of a pandemic, and if they determine that you have the coronavirus, and that's just an example, then what it means is that you could potentially be denied entry into Canada and be found to be inadmissible because you would be rendered a danger to public health, right? So you can be inadmissible for that reason. The other reason for which some people can be rendered inadmissible is if you suffer from some kind of a medical illness that is costly to treat. It costs a lot of money to treat it. And if you were to come to Canada, it could potentially create a burden on Canada's healthcare system. It could create what's called in legal terms excessive demand. Okay. Now there's a threshold which has to be met, and that threshold has been raised. So what it means in essence is that whereas in the past medical inadmissibility was a major reason why people couldn't come to Canada, in the last 3 or so years, it's no longer a major issue because the dollar value, the monetary cost that it will cost you to treat that illness in Canada has been raised, and so if you have an illness, for instance, that's going to put a $5,000 per year burden on Canada's healthcare system, then that illness will not render you inadmissible because that $5,000 figure falls below the annual threshold that the country has. But the answer to the question is yes, one can be found to be medically inadmissible to Canada for 2 reasons. One, because you are found to be a danger to public health because you have some kind of infectious disease, or 2, because the illness that you have may cause some kind of excessive demand on Canada's healthcare services and social services.
What if someone, let's say someone has HIV? Let me use HIV
Yes.
number 1, and
Yes.
then maybe in family they have a child with autism, so a child that is autistic and a child that has cerebral palsy, or maybe what else? One of this ADHD, this behavioral mental situations, and then maybe an adult that has a bipolar disorder.
That's a lot of problems for one family there, Willa.
What?
That's a lot of problems for one family.
I'm not talking about one family. I'm just referring.
Yes, got it.
Let's say one person has HIV, another person, a family, they have an autistic child, and then maybe another person has behavioral disorder like bipolar disorder, mental schizophrenia, all these things. Once evaluated, is there a likelihood that these things can also affect inadmissibility? Medical.
They can. I'm just having a quick look to see what the dollar value of the threshold amount is, because ultimately that's what's going to matter. Kind of how much in terms of a dollar value the impact is going to be on Canada's health care services and Canada's social services system. It's not going to be, they're not going to be inadmissible because they're a danger to public health. No. So somebody with HIV, for instance, isn't going to be prevented from coming to Canada because they are a danger to public health. What will come into question is how much will it cost? How much of a burden will it put on the Canadian government, the Canadian health system in terms of dollar value, if this person were to be admitted? Okay, and so this is 2018. So the threshold, the annual threshold that I'm seeing here right now is just under $20,000 per year, right? For the 2018, the new threshold is that over 5 years, which is about $20,000 per year. So what it means is that if it's going to cost Canada's healthcare services more than $20,000 per year to treat the particular illness, then it's likely that that person is going to be inadmissible on the grounds that they're going to be putting excessive demand on the healthcare services. However, if it's going to be costing less than that per year, then it's unlikely that they're going to be found to be inadmissible. And if somebody applies and they're found to be medically inadmissible, then what happens is they're not just denied off the bat, right? They always have an obligation to provide what's called a fairness letter, which is a letter that says, you know what, we believe that you're going to pose an excessive burden on our system. Please tell us why we should not find you medically inadmissible. And that then gives you an opportunity to get your lawyer to put together reasons to explain why you will not be a burden on the system, and it could be for a myriad of reasons. Maybe you don't require some of the medications that the Canadian authorities think you're going to need, and therefore your medical, your pharmaceutical bill is going to be lower. It can be for many reasons, right? But the important thing to understand is that you can be found medically inadmissible, and if you are, then you're going to be given a fairness letter, and you will have an opportunity to put forward your own arguments as to why you should not be found medically inadmissible.
Okay, so yeah, so this person is asking, that's Shekina, please, I want to know if my
Mm-hmm.
previous denial at the US can affect my application to CA, even though I'm currently studying in the Philippines. I think that question has been answered before. Maybe you could still,
Mm-hmm.
yeah. So if you have been denied any visa before, it is best to be upfront.
Mm-hmm.
And mention it in your application that you were denied a visa before. You cannot just apply
Yes,
and say, no, you were never denied a visa. If you have been denied any form of visa anywhere before, you have to put it in your application that you were denied so that it doesn't lead to misrepresentation, and misrepresentation would lead to 5 years ban. I'm trying to look
that's right.
for, yeah, I'm trying.
Yeah, and sure. What clients, what we usually advise clients as well is that they need to understand that many of these countries, the Canada, the US, UK, Australia, they share information. All
Mhm.
right. So a lot of the immigration related information is shared. And so somebody who's denied entry to the US, for instance, or who has some kind of an issue with the US immigration authorities, that is likely going to show up in Canada's border services systems as well. And so knowing that these countries share information, you want to be very, very certain that you are not misstating any information as it pertains to any immigration interaction you might have had with any of these other countries.
Okay, so one person was asking, does provincial nomination ineligibility count as visa refused? No, I don't think so. But Mr. Francis, can you put more light on this? I don't think so. The person has actually not applied for any visa, just a provincial nomination that was
No,
refused. So maybe the person is
no.
thinking if the information submitted during the provincial nomination could be shared with IRCC, and then maybe IRCC would see that this person was refused a provincial nomination before, and it could affect the application. I think that's what the person is trying to know, if it would affect the application sometime, maybe.
Yeah. So when you're asked that question on the immigration application, if you say yes, there is a field for you to give an explanation, right?
Yeah.
So it doesn't matter. It doesn't matter what the refusal was. If you have any uncertainty, you put yes, and then you put the reasons. And the purpose of this question is not to deny you your application, right? It's just to understand if there might be any issues that the authorities need to be alert to,
Mhm.
right? So the fact that you might have been denied an application for a provincial nominee or a US visa application does not automatically mean that the Canadian authorities are going to use that against you in making a decision on the specific application that you're making at that particular point in time, right? What you want to do is ensure that you're upfront and you're honest, you're truthful. And if you have any doubts, put yes and put the reasons there, and that should be fine.
Okay, then I have another question, and nobody has asked it, but I think I'll ask it on behalf of someone who is not here.
Yeah.
Let's say
Mm-hmm.
somebody claimed to be a business administrator and applied for a US visa. And now the person wants to apply for Canadian visa, and the person is claimed to be a human resources professional. Those are two wrong, inconsistent, not wrong, inconsistent information. The person was denied a US visa, and the person wants to apply for a Canadian visa, and they are having inconsistent information with regards to the application. When the info sharing, when there's information sharing between the US and Canada, do you think that would likely come up and maybe affect the person's application based on inconsistencies?
I don't know. I don't know the level of sharing that occurs. I know that when somebody is applying on the express entry, for instance, you're required to provide reference letters
Mm-hmm.
that detail your previous employment history and all of that stuff. You want to ensure that that's credible. But I couldn't speak to the level of sharing that occurs between the two countries. The best I can say is try to be as honest and truthful with the information you're sharing as possible, because you want to keep as far away as you possibly can from being found to have misrepresented, because there's so many challenges that come with such a finding.
Okay. This question here. A family friend with a valid UK visas and a refused US visa has applied and got denied a Canadian visitor visa twice on grounds of doubts. They will return and links to Nigeria. How should they reapply?
Okay. So again, it comes down to the reasons. I mean, that sounds like a generic, they got the generic response in a refusal letter,
Mm-hmm.
but they want to understand the true reasons, the specifics of what the officer would have written into their notes. So that would be the first thing that I do. And then based on the reasons provided, I would then formulate a response. Obviously, yes, whatever the officer's reasons were, they're going to be tied in some way to an absence of adequate ties to the home country. So we would have to have a discussion around what that person's ties to Nigeria are, in terms of financial ties, in terms of employment ties, in terms of family ties, and how's the best way to show that those ties exist.
Mm-hmm.
Yeah.
Okay. So most of the questions I am seeing are actually related to what we have already treated. So I'm trying to look for something that has not been treated before. One person is
Mm-hmm.
asking concerning health issues. I don't know if it still falls under what you have talked about already. Health issues like sickle cell, SS genotype, if they'll fall under medical
Mm-hmm.
inadmissibility. But like Mr. Donovan has already said, everything is calculated based on the dollar value of the medical threshold that
Mm-hmm.
has been provided by the government of Canada. And if
Mm-hmm.
they calculate, okay, that reminds me, I have to ask this question on behalf of anybody. Is it possible for maybe people with medical issues to do, let's say, a cost, a how will I put it now? Just maybe find out if there is a cost to what they are actually spending
Yes.
in dollars, that would maybe to
Yes.
help them have an idea if they can pass the medical inadmissibility or not. So would you encourage
Right.
them to prepare a cost on their own? Let's say for a year they
Yes.
find out, okay, how much have I spent on this treatment? If I have a kidney failure, how much have I spent on kidney failure? How much have I spent
Mm-hmm.
on dialysis? How much have
Mm-hmm.
I spent on maybe diabetes? How much have I spent on this medication? Can they
Yeah.
do a self cost before they go ahead to start applying for immigration, or they should go ahead and apply and then wait for the report of the medical doctors?
Yeah. No, I think you're correct. You and that's something, that's what we do when we know that there's a medical inadmissibility issue. We help the clients kind of start the process of trying to show that the cost, what is going to be costing them to treat the particular illness that they have, will not exceed the threshold that Canada has. So absolutely, the person will want to start getting a sense of what their pharmaceutical costs are, what if there's some kind of social services involved, if you have to go get therapy and all of that stuff, you want to understand what those costs are. And then when you've calculated all of that, you want to see how that matches up to
Mhm.
the dollar value threshold that Canada has. right? Because we are going to have to make a case in our submissions on your behalf to the authorities to say that even though you have this illness, it will not add up. The expenses will not add up to more than the threshold that the government has. So absolutely, they will want to start getting an understanding of what kinds of costs are involved in this process beforehand. And if you know that you have a medical condition, then what's going to happen is that when you're asked to do your medicals, the doctor who does the medical is likely going to discover that particular medical condition, and that information is going to be shared with the immigration authorities. Okay, and the authorities now are going to review it and then make a determination as to whether or not they think that the cost that will be incurred is going to be greater than the threshold. If they think that is going to be greater, then they're going to send you this fairness letter. And so you want to be prepared so that when that fairness letter comes, you would have had all of this information kind of ready to respond.
Okay. Yeah? Okay. That's a good one. Yeah. So for anyone who has any kind of medical condition, it is best to start knowing what cost it will involve, so you prepare yourself ahead of time. Yeah, that's a good one. Thank you so much for that. Then no, this is not a good question. I thought I had a good question there. I saw one question. Okay, someone is asking for your contact details. You can Google Goose Law, but I will put the contact details when I eventually upload this video. And he also, I think you have a YouTube channel as well, so they should also.
I do. We're at Goose Law TV Immigration. So we share videos with persons weekly. So that's one good way to reach out to us as well.
I think I saw one question that I had tagged, but now I can't find that question. I'm trying to look out for the question.
That's fine.
This person is asking, please, can you explain if someone was denied Canadian visa and he appealed using immigration lawyer, was still refused? Please, well, the question is not clear. I don't know. Maybe you would understand it.
Maybe. Please kindly explain if someone was denied Canadian visa and has appealed using an immigration lawyer, if he's still. So using a lawyer does not guarantee you that your application is going to be approved, right? Yeah. Using a lawyer, using a consultant does not guarantee anything. Canada's immigration laws allow the immigration officer to use what's called their discretionary power. So ultimately, the officer has the power to decide whether or not to grant your application. What you will get by using a lawyer is that you will get the opportunity to submit a much stronger application, right? So the lawyer is going to help you identify issues in your initial application. The lawyer is going to help you get the reasons for the refusal and address each of those reasons and make the application stronger. But ultimately, no lawyer or no consultant can guarantee you the outcome. Okay, and that's important to note, because I know that there are people who represent themselves as being able to guarantee applicants an outcome. That is not true. That's dishonest. Nobody can guarantee that, because that decision is up to the officer, nobody else.
Okay, so this question, please, does one's express entry profile affect study visa application? Wouldn't it send signals that applicant is interested in immigrating?
Yeah, that's a good question, actually. So Canada's immigration laws allow for something called dual intent. And what that means is that it is perfectly fine for you to have applied to become a Canadian permanent resident, and then while you're waiting, choose to apply to come as a temporary resident as well, whether as a student or as a work permit holder. That is fine, no issues. Where it becomes an issue is if the immigration authorities determine that your intention is not really dual, it's not two, it's actually one, that you have a singular intention, which is even though you've applied for permanent residency, you can't wait, and so therefore you're wanting to use the study permit route to get to Canada and not leave. Okay, so that's the only time it becomes an issue. And so what we do is we try to show that if somebody has a permanent residency application in place and they're now applying to come as a student, we try to show that even when they come as a student, they have sufficient ties back home and they have sufficient reason that would warrant them going back home and not trying to stay in Canada and waiting for their PR application to be finalized.
Okay. Okay, so we have 9 more minutes left. Yes. Mr.
Wow.
Francis has been talking so much today. So one question, he said, okay, I don't know if I applied for a B1, B2 visitor's visa, but didn't move past the visa interview stage. Is that a visa denial?
Not sure. So those are US visas. When you say you did not move past the interview stage, I'm not sure what that means. Does that mean that they got back saying, no, you're not going to be, it may well be a refusal, but I'm not sure what the US visa process is. I'm not sure.
I think, let me explain here. For some countries, like my country where I come from, for you to get the visa, you have to go through an interview process, right? So if you go for the interview and they tell you, we're sorry, blah, 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 that is a visa denial. They don't take your passport. So you have to physically present yourself at the embassy, and then during the interview, you would know if your visa was successful, if your application was successful or not. So I think that's what this person is referring to. The person went to an actual interview, but doesn't know if that could count as a visa refusal or not.
That sounds like a visa refusal to me.
Okay.
So for you to have gotten to the interview stage, you must have filed an application. She must have filed an application, correct? She must have completed an application form, provided all of her details, and following that submission, should have gotten an invitation to an interview. Right? And then upon doing the interview, you then get turned down. So that sounds like a denial to me, and it is likely that this person would have gotten some kind of a formal communication from the U.S. Authorities advising them of this. I don't practice U.S. immigration law, so I can't speak definitively, but based on what you've explained, it sounds to me like that would be a visa denial. But remember, there's nothing wrong with indicating yes and then explaining exactly what happened in your application form. That would be erring on the side of caution.
Okay. So one person is asking, refuse visa based on the fact tie in my hometown and tie in Canada, also purpose of visit. How will they address that?
Yeah, I mean, I think it comes back to the same thing we've been saying today. You know, we want to see the exact reasons for the refusal, and then once we're clear on that, we want to strategize. We want to understand what kinds of financial connection this person has to their home country, what kinds of family connections they have, you know, what kinds of job, professional connections they have. What kinds of business connections they have. All of these things, we want to kind of assess them to see how best we can formulate a response on their behalf to address the concerns that the officer would have raised inside of the reasons.
Sorry, there's a siren. I don't know whether that's been. I don't know if you could hear the siren that just passed. Okay.
Yeah, I did.
So this is the very last question. And yeah, he said my study visa was refused and I'm planning on reapplying for another school. Is that advisable?
Okay. It depends. We need to understand what the refusal was, what the reason for the refusal. It always comes down to the reason for the refusal, you know. Was the refusal based on did it have anything to do with your program of study, with your chosen program of study? If it did, then maybe that's advisable. If it didn't, then I don't know. So it's going to come down to the reason for the refusal. We'd want to see what the officer's reasons were and then be guided by that. I think that has to be the safest approach.
Okay, so apparently, if let's say I decide to change schools, it doesn't affect the application. Would the visa officer think this person is confused or what? You know, some people have this.
I mean,
If I
yeah,
applied to school, I was denied a
yeah,
visa. I
yeah,
should still retain the school, whereas I have seen a
yeah,
better school. If I change the
yeah,
school, the visa officer might be thinking
yeah.
I'm a confused person, right? So,
I think it's not so much a matter of the school, but rather the program of study, right?
okay,
So if you've decided to change your program of study, I mean, there's that possibility. But then again, it depends on the reasons. If the officer told you in their refusal that they don't see a logical connection between your degree, your first degree that you did in your home country, and your chosen program of study in Canada, then I mean, perhaps the best way to address that is either try to explain it away or identify another program which more logically connects. If you did a first degree in nursing in Nigeria and you've applied to be admitted into a 1 year computer science program in Canada, an officer could argue that they see no connection between the two, right? You could address that concern by either one, trying to explain to the officer that you're interested in the IT side of nursing, in doing IT related stuff in the nursing field,
mhm.
one, or you could decide, okay, you know what, I'm not going to do this IT course. Instead, I'm going to apply for a master's program in nursing, right? So in that situation, it may make sense for you to switch from wanting to do the IT program to you wanting to do the master's program. So it depends kind of on the reasons for the refusal, in order for us to really provide some good guidance on that.
Okay, so we just have 3 minutes left. I want to say a very big thank you. Let me not take too much of your time because left for me alone, I can talk for hours. I can
No,
keep
it was a pleasure.
hours. So I'm so happy and appreciative that you joined on this live to explain these issues. In 1 hour, at least a lot of people have had their questions answered and they would know what to do. And for anyone who wants to contact Mr. Donovan Francis, Mr. Francis Donovan, anyone, yeah, I would put his details on the description box of this video. I'll upload the video later for people to watch. So I'll put his details on the description box of this video. You could also join his, what's the name of your YouTube? I didn't check.
Goose Law,
Okay, good.
Goose Law Immigration TV.
Okay, you can also subscribe to his channel, Guzlaw Immigration TV. His immigration firm is called Guzlaw. So if you want to talk to him, if you want to consult with him, you can find his details on the description box or just Google Guzlaw, Gooseelaw, Guzlaw, and you will see him. His picture is there, so it's not someone else's picture. It's not a whatever. His picture is there. You will see him there. You can contact him from his website. And if you have any issues, if you have been refused your visas before, if you want your visa to go through a reconsideration, sorry, if you want your study permit application to go through a reconsideration, if you want to apply for anything, you can contact Mr. Donovan and he will be able to assist you. He's a Canadian immigration lawyer. So I didn't bring just anybody. I brought a Canadian immigration lawyer to discuss these issues. So you know you're talking to somebody who is on a premium level, not just a low level, a premium person. So yeah, I want to thank you so much for joining me on this live. And I
Yeah.
think a lot of people had their questions answered. For those, if I didn't answer your question, that means it was not related to the topic. I'm sorry. I have to be very fair on that. It's only people who ask questions related to the topic that I'm able to provide answers or actually showcase their questions. So I think that brings us to the end of today's broadcast. I want to say thank you so much, Mr. Donovan. Thank you for joining us. And hopefully we'll have lots of people contacting you for their issues. A lot of
Thank
people,
you. And
yeah.
Thank you. I just wanted to thank you, not just for the opportunity to talk and to address people's questions, but for the good work that you're doing. You know, I mean, there are lots of people who want to hear from somebody who's gone through the process like themselves, and somebody who's an immigrant to Canada like themselves. And I think you're doing an excellent job. So I just want to thank you for the good stuff that you're doing as well.
Thank you so much. It's a passion. I'm just passionate about it.
I can see that.
people don't fall victim of fraudsters. You know, there are lots of fraudsters all over everywhere. And they are taking advantage of people who don't understand the process. So I'm more like bridging the gap between what is authentic and what is not, so that people are aware.
Yes.
Yeah. Thank you
so much.
Okay.
All right.
Bye.
All the best. Bye.